I'm Ben Meiselas from the MeidasTouch Network. Donald Trump just got smacked down by federal judge Lewis Kaplan from the Southern District of New York. Donald Trump was seeking to stay or delay or pause the proceedings before Judge Lewis Kaplan in the new E. Jean Carroll defamation trial. Well, technically, it was the first E. Jean Carroll case to be filed, but it is the new one set for trial in January of 2024. Actually, the first few weeks of January 2024, jury selection and trial there. And this relates to Donald Trump's defamatory statements made back in 2019 while Donald Trump was still in office. Donald Trump went through proceedings in state court after E. Jean Carroll filed back in 2019. Thereafter, Donald Trump had the Department of Justice, run by Bill Barr, who Donald Trump now calls a traitor, substitute in place of Donald Trump so that the case would be E. Jean Carroll versus the United States. There was a whole appeals process that took place. Eventually, the case got sent back to federal court before Judge Lewis Kaplan, and the other defamation case went first, earlier, right before this summer, and Donald Trump was found liable by a jury to have engaged in sexual abuse as well as defamation. E. Jean Carroll was awarded $5 million in that matter, and then the new case is slated to go to trial in January of 2024. In this order, by Judge Lewis Kaplan, not only does Judge Lewis Kaplan reject Donald Trump's attempt at this stay pending an appeal, but this is a scathing order, a scathing smackdown. And Judge Lewis Kaplan states here that this was a patently frivolous request by Donald Trump. Here it is right here. It says, Trump's assertion of this immunity defense in trying to stay this matter fails on the merits. And it says, this court certifies that Trump's appeal is frivolous and therefore has not divested this court of jurisdiction. And so what Donald Trump was trying to claim here, as the court points out, a little late, buddy. Donald Trump's like, what I was really entitled to have is presidential immunity because I made those statements while I was in office. So as one of my affirmative defenses before we go to trial in January of 2024, I want to assert presidential immunity. And Judge Lewis Kaplan says, well, one, that fails on the merits. You don't get presidential immunity for defaming somebody like E. Jean Carroll and saying horrific things, especially where you've already been adjudicated by a jury to have engaged in a sexual assault and defamation. So there's no basis for it. But in any way, Donald Trump, your lawyers are morons. I mean, Judge Lewis Kaplan didn't specifically say that, but you and your lawyers are morons. You are raising this so late. Years have passed. You've waived the right to assert immunity as a defense. That should have been asserted in 2019 or 2020 when the paperwork was first being filed. Instead, you waited and delayed. And by the way, it's pointed out in this order, you've requested a stay of these proceedings 4 times now. This is the fourth request. And for the same reason it was rejected the first, the second, and the third, nothing has changed except for the fact that in the other E. Jean Carroll case, you were found liable for engaging in the underlying sexual abuse. And as Judge Lewis Kaplan says, the only issue at this point for this court to decide is going to be the preclusive effect of the other E. Jean Carroll case, which is labeled E. Jean Carroll 2, where a jury already found you, Donald Trump, liable. So there is already briefing taking place, and E. Jean Carroll's lawyer, Roberta Kaplan, no relation to Judge Lewis Kaplan, brought a motion about the preclusive effect. And in that motion, Roberta Kaplan, E. Jean Carroll's lawyer, argues, look, A jury found Trump to be liable of the underlying conduct at issue, so the statements, as a matter of law, should be determined to be defamatory because Trump engaged in the underlying conduct, the sexual abuse, and Donald Trump was found to have engaged in defamatory statements. So really, Judge, the only issue under estoppel principles, which is like the preclusive effect of prior rulings or prior jury holdings, means, Judge, really all the jury should be deciding at this point are damages. And E. Jean Carroll will be seeking at least $10 million in damages in January. Donald Trump will file an opposition brief to that. And ultimately, seems like E. Jean Carroll will almost certainly prevail in her motion. That will have the judge make a finding that all that the jury will be deciding on is damages. And E. Jean Carroll's lawyer, Roberta Kaplan, will say the following. Ladies and gentlemen, it has already been determined that Donald Trump committed a sexual abuse. It has already been determined that Donald Trump defamed E. Jean Carroll. For that conduct, we are requesting X millions of dollars in damages, 10, 15, 25, $50 million in damages, and punitive damages. And let's talk about punitive damages, ladies and gentlemen of the jury. As per usual, the economy was also a huge topic for the day. And why wouldn't it be? It's changing faster than ever and demanding we all adapt to keep up. In fact, a stunning survey revealed that over half of Americans making six figures now live paycheck to paycheck. Now, even though Goldman Sachs is saying the classic investments are headed nowhere for the rest of the year, other markets are rising to fill that gap, creating incredible opportunity among the chaos, because even if conventional markets flatline this year, other assets don't have to do the same. That's why I'm excited to introduce our next partner, Masterworks. I actually spent a lot of time digging into this, and according to a recent report by Citibank, the asset with the lowest correlation to the stock market of any major asset class was art. It turns out contemporary art prices have outpaced the S&P 500's return for the last 26 years by 131%. Now, this market used to be hard to get into, but Masterworks is the platform that lets you invest in multi-million-dollar paintings without breaking the bank. Masterworks has built an impressive track record of 15 exits, all of them profitable. These numbers speak for themselves. Now, with those kind of results, Masterworks offerings have actually sold out in minutes before. So there is a wait list. Now, although I have invested, and as with any investment, past performance is not indicative of future returns, and exited investments are not representative of performance for artworks not yet sold. But I reached out to them to give you all VIP access to their latest offerings to skip the wait list. Head over to masterworks.art/MeidasTouch to skip that wait list, or just click the link in the description of the episode below. That's masterworks.art/MeidasTouch, masterworks.art/MeidasTouch, or just click the link in the description of this episode below. That's masterworks.art/MeidasTouch. Now, E. Jean Carroll's lawyers did something so brilliant when they amended the E. Jean Carroll 1 case, the one that's set for trial in January. Where they amended it, they didn't bring an entire new action yet based on Donald Trump's new defamatory statements about E. Jean Carroll. Remember when Donald Trump, after the verdict was against him, he went on that so-called CNN town hall with Caitlin Collins, and then he started defaming E. Jean Carroll more? You remember that? That forms an independent basis if E. Jean Carroll wants to sue Donald Trump again. E. Jean Carroll will have at least a year to make that determination if she wants to sue him for that independent defamatory act, which she can. But in the meantime, because E. Jean Carroll's lawyers did not want to slow down the other defamation case, what they did is they just added the allegations of Donald Trump making more defamatory statements in support of punitive damages, because one of the bases for punitive damages is its deterrent effect and the malicious nature and the ongoing conduct. So constitutional limits on punitive damages, generally anything more than 10 times your compensatory damages would be per se unconstitutional. And if it was more than 7 times, I think in New York, you're probably cutting it close, even though it's in federal court. So let's just say E. Jean Carroll requests, I don't know, say $25 million, right? And then I would assume E. Jean Carroll is going to ask for punitive damages on top of that of what? 7 times that. So let's say she requests $175 million in punitives, $25 million in compensatory damages. I think that there's a world where the requests can be for $200 million in damages that could be requested by E. Jean Carroll's lawyers. And that's happening in January. Okay, so as that's happening in January, what's happening in October? The New York Attorney General civil fraud case against Donald Trump, where Letitia James is seeking at least $250 million against Donald Trump, his adult children, other than Ivanka and the Trump organization. So lots of things moving there, but this scathing order, in the meantime, by Judge Lewis Kaplan here, denying Trump's request for a stay, and just basically saying, if you go to page 3, for example, Trump's previous motions to stay this case. And I like the way that I don't call him president or former president. It's Mr. Trump or defendant Trump. This motion is Mr. Trump's 4th attempt to stay this case. He first moved to stay it while it was in state court. Trump's 2nd and 3rd motions to stay made before this court also were both denied. Trump moved a 3rd time to stay this case in conjunction with the 2nd motion that he filed. And the only developments, the current status of this case, is that Trump lost the underlying defamation case, the first one to go to trial. And I think one of the important things that's stated right here in the outset, and Judge Lewis Kaplan wants to be very clear what occurred. He says, a little less than 4 years ago, writer E. Jean Carroll commenced the defamation lawsuit against then President Donald Trump for certain statements he made in 2019, shortly after Ms. Carroll publicly accused him of sexually assaulting, raping her in the mid-1990s. This case was largely stalled for years, due in large part to Trump's repeated efforts to delay, which are chronicled in the court's prior decision. Trump's latest motion to stay, his 4th such request, is yet another such attempt to delay unduly the resolution of this matter. Motion to stay denied. I'm Ben Meiselas from the MeidasTouch Network. Go to MeidasTouch.com for all the breaking MeidasTouch news. That's MeidasTouch.com, and wherever you get audio podcasts, check us out as well. Just search MeidasTouch. Have a great day.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.